So my name is Allison Walton, and I'm an eDiscovery attorney for Symantec. I support the sales teams by explaining our information governance and eDiscovery capabilities. But today I really wanted to cover some of the 5 best practices that organizations can implement in order to address some of the concerns that were spoken about this morning by the AG. Who was in that meeting? And then who in the audience is an IT person versus a lawyer or both? IT? Lawyers. Excellent. Okay, so this morning we spoke a lot about what you need to do with document retention and how you should manage things, but we didn't necessarily get to how you can deploy those things in an automated way, in a non-manual way, right? So we're going to cover that a little bit today, but just like Stephen Covey, I thought it would be nice to hit 5 real points that are actionable. So we are in some exciting times, right? Because the data explosion is happening right now. I mean, if we think about the amount of data that we've created since 2011 to what we're going to see in 2015, it's phenomenal. And so governments grapple with this uniquely because they also need to be the records keepers of this information. So you have your litigation, you have your records, you have all of it. So on our agenda today, we'll cover some of the challenges that are unique for the government, and then we will go over some of the case law and the defensibility, as well as the 5 best practices, and then Q&A. So I'd like to open this up for questions iteratively as we go along. I think if you have one, just ask. So at Symantec, we have this term that's really not new, but we've redefined it. Who here in the room is familiar with Gartner, the analyst firm? And do you use them for anything? Do you read their reports and listen to them? Okay, so we work obviously closely with all of the analysts in the industry to go over our products, specifically with eDiscovery, it's information governance. So it's archiving, which is Enterprise Vault, and Clearwell. But we've defined information governance as something a little bit different. We see it as what were once disparate issues, information management, eDiscovery, and data security, are rapidly coming together due to the explosion of electronically stored information and the on-premise and cloud-based technologies that deliver and disseminate it. Organizations are increasingly demanding that these issues be addressed in a unified way through information governance. So at its base level, information governance, it has priorities and responsibilities assigned to people, but from a technology point of view, what we're saying information governance is at its baseline archiving and eDiscovery. So what does make the government different, right? A lot of litigation, a lot of civil litigation, a lot of criminal litigation, a lot of record-keeping requirements. So this goes back to the push and the pull that everyone is experiencing, right? They talked about document retention this morning, but what I was dying to ask, and I was just going to say for my presentation, is how do you reconcile the FOIA requirements and the record requirements with what you're doing with your document retention policies? And I think someone kind of answered that question, but I don't think it's been explained technologically. If you have an archive in place or any other proprietary document management system for records, then you're able to get a handle on how you're keeping your records, right? So she said backup is for recovery and archiving is basically for discovery. That's all true, and that's exactly the way that information should be approached. But you also have to automate and look at all of the record statutes and then look at what's required for litigation in tandem and automate those things across an archive. Does that make sense to everyone, or does anyone have a question about that? Because it really, if you look at the universe of data that's within these government agencies, it's so much, and you're going to be in trouble if you delete the wrong thing, and you're going to be in trouble if you save too much of the wrong thing, right? So it's got to be analyzed, and it's got to be a committee, and you have to sit down with a policy and get that policy effectuated with the technology. So that's definitely one of the major challenges that the government faces that the private sector is not facing in the same way. Private sector clients in the Fortune 1000 can say, I only want to keep my email for a week. And that's not something the government can really do due to FOIA. Then let's add insult to injury between 1 and 2. Not only can you have litigation, and not only can you have FOIA production requests, but then you can have litigation about FOIA. So what are the workflows surrounding this within these organizations? Does everyone have the ability to address them holistically? Are they doing completely different workflows for one versus the other when really they're discovering the same information that could be repurposed and utilized? Now, granted, you're going to want to redact information from FOIA requests with technology. I mean, I know still in some agencies, people are taking emails, printing them out, using a Sharpie to block something out, and then producing it. We could talk a little bit about that later, but that's hopefully coming to an end. But the same tools can be in place in order to accomplish both things, and I think that's what I'm trying to say with this. Massive volumes of data, I mean, terabytes and terabytes. So definitely in the midst of the information explosion with no signs of slowing down, especially given that mobile devices and social media and all those other mediums upon which people are creating information have no plan on how that information is going to be destroyed, whether it's going to qualify as a record, or if in fact it's going to be discoverable in a third-party atmosphere, in the cloud. You know, if you're a government agency and you have your employees using Facebook, have you read the consent agreement with Facebook, and do you have an eDiscovery plan to go collect that information, for instance? That's one of many examples. Limited resources. You know, I know one thing my team here, and I talk about a lot, is, you know, how can we address these challenges and how can we help these agencies? But, you know, it's very difficult to understand all the underlying pinnings of budget and timing and politics. And so that, I know, is such a stress, right? Because, and private sector doesn't have the same dynamic. And so that's another difference that needs to be managed when looking at these things. And then finally, I was actually just speaking to a gentleman when we were at the Keynote, and he said that his agency just went through a complete digitization of all their records. So we're seeing that. We're seeing an investment in taking the paper that needs to be around, putting it into the right format, and then having it be part of the corpus of data of ESI, electronically stored information. So that's happening. So those are the 5 major challenges, and then we're going to map the 5 best practices to those today. Any questions so far? Yes, sir.
Their conversion, are they doing also OCR, or is it just purely image? And they're converting the paper?
They're OCRing it so they have the ability to text search. Right. Yeah, they're giving the document multiple. Go ahead.
Accuracy, because that's a big problem.
That is, and I know about a few technologies that Symantec partners with. Beyond recognition is one of them. They're improving. In fact, I think they're almost at 99%, and that kind of parlays into the predictive coding conversations we're having about records versus litigation. So if we have a little bit more time after, I can expound on that. But definitely, I wouldn't even consider not OCRing a document that needs to be digitized.
I would like the image as well. That would be a backup.
Okay. Are you a forensics guy? Are you coming from forensics? Okay. Yeah, I mean, I think that's a negotiation that happens in the Information Governance Committee, which is another thing that we're seeing happen. You know, all of these people have been fairly siloed, and people are coming together to put these types of issues on the table. In fact, that's what I would use these 5 steps that we're talking about today for, is if there's going to be an information governance or eDiscovery meeting amongst stakeholders in these agencies, these 5 points are a good place to start. But we could talk about that more, but the more data you can get when you're imaging your documents, the better. Wrapping our minds around the costs of eDiscovery. You know, this is the big push, and this is why eDiscovery is so popular when you look at the private sector, because corporations want to save money. They want to save money on the review. The review is very expensive, and they don't want to pay lawyers like me $500 an hour to make, 30-second judgments on documents about whether they're privileged or relevant or whatever. So what ends up happening is the amount of eDiscovery expenses that they're rolling up at the end of the year are almost costing these lawyers in-house their jobs, right? I don't think that same dynamic is existing in the government. I think there's so much pain here because of the amount of data and how difficult it is to process it, review it, cull it, and those types of things. And that's true for productions that you're making for freedom of information requests or the state equivalent, and that's true for the information that you're receiving in that you need to analyze, whether it's for an investigation or the Environmental Protection Agency needs to see things that companies are doing, right? So I don't know how much the government focuses on the true detailed costs of eDiscovery, but let me tell you what they are. They can range between across the entire electronic discovery reference model, which, by the way, does everyone in the room know what that is, or would everyone like a quick rundown on it? Okay, so the electronic discovery reference model was developed by George Sosha and Tom Gelbman in Minnesota. The EDRM model is something that's very difficult to miss when you're talking about eDiscovery. It's the framework of how to have that discussion, and those two gentlemen are the grandfathers of it. So if you got the resources from this morning of the Sedona conference and those other sites, the EDRM model is crucial because it sets the stage, and that's going to be coming up on another slide. But essentially, across the information management, identification, collection, preservation, processing, culling, reviewing, and production of information. Those are the steps that the EDRM has on it, and that's a context upon which you say, okay, this is my job duty, and these are my tools, and this is where this action takes place regarding that data. So eDiscovery can cost between $5,000 and $30,000 a gigabyte to complete those 9 steps. But no one, I think, in the government's really, and maybe I'm wrong, and I'd love to hear that, but I don't think anyone's ever gone through the line item expenses of what this costs. So it's good to look at the numbers. But let's contrast that with another thing, which is storage is cheap. It's 20 cents for a gigabyte to store data. So what does that do? That makes us hoard data, right? It comes basically down to these massive repositories, whether they're backup tapes or other things, that haven't been expired. Why haven't they been expired? Because document retention policies haven't been applied to them, right? And now when you have to go back and get something, and it is readily accessible, you have to get it, cull it, review it, go through the whole process again. So you're paying more for junk that you're keeping than it's worth. Makes sense, so. But on the other hand, you need to make sure it's not a record if you're going to expire it that you need to keep for FOIA purposes. Okay, I thought this would be interesting for the group just to get a little bit of sense about what your colleagues are doing. So this first question here, we did this survey at the EDGE Summit, which is the biggest eDiscovery event for the government in the year, every year, and it's in Washington, D.C., and a bunch of state, local, and Fed people were there. And we were introducing this concept of information governance, and we asked them what the biggest factors were in them choosing, or the drivers were for them to get a solution. And it was kind of tied. So upwards of 70% of people felt that internal investigations, whether they be congressional or HR related within the agency, lawsuits and FOIA requests were all over 70%. So I'd be interested in this room for a show of hands, at least, respectively from investigations down, what are the biggest pains associated with going back and getting your data, or reasons that you're considering archiving an eDiscovery? I mean, do these resonate with any of you here? Yeah? No one seems to care about investigations for third parties or criminal. But I think that this is interesting because it shows us what the drivers are. If we move to the next one, we look at the challenges, right? I thought the challenges were going to be more politics and budget. The challenges truly are getting multiple groups to work together, breaking down the silos, getting IT, InfoSec, HR compliance, legal, all these people in a committee to understand what this really means and why it's so important. I just sat in on the FBI presentation about cyber attacks. I mean, to not include the security officers and the CISOs, in these conversations about how all the information is being governed is a big mistake. Moreover, the more people you include, the more people can be responsible for it and pay for it. It doesn't have to be something that only IT absorbs. It's like a company problem. So breaking down silos and working together was huge as a problem, and not far behind are technical obstacles. So we were talking a little bit, too, about different repositories for classified data, unclassified data, things like that. That presents a little bit of a problem when you're trying to roll out a massive information governance solution. So you may have to have many information governance solutions for each data center or repository that you want to deal with, depending on the grade of the data. But at the end of the day, what the government, I think, needs to do is to be completely digitized, and then this will be a lot easier. So legacy data can be migrated over with the imaging, as we were just discussing, and there needs to be some proactive planning to get it all sorted out. And then at 61% was no consensus on records, categories, and retention periods. I'd like to think that the lawmakers have already kind of come up with what you need to do for the records. And then otherwise, it's just how does your agency function and what's reasonable. It's really a reasonableness test. Finally, what are your goals for your information governance solution? Now, this is interesting given that we just spoke about how much eDiscovery costs, right? So people are very concerned with finding the data that they need when they need it, especially as this information grows. We're just having to go into a deeper, larger haystack for that needle. So they want what they want when they want it, and then they want to comply with legal hold requirements. So it seems that everyone has a good appreciation for what legal hold is in the room. I mean, it is a common law, precedent-set standard that when reasonable anticipation of litigation exists, you've got to start preserving and identifying custodians and locking that data down. Now, one thing I think we were just missing a little bit from this morning, too, is how are people locking that data down? If you don't have an archive, you can't. You cannot hold things in place without an archive. So if you're operating, that's why I was very curious about how often are agencies having to go to backup tapes in order to restore information for FOIA or for litigation. Because if they don't have an archive, it could be deleted. And then if it's deleted and it shouldn't have been, it's spoliation. I mean, the whole thing is just this like circular, you got to, from left to right, get on this information governance plan, essentially, where you're archiving and then you have proactively. Then you have archiving tools that can help you reactively. But only 46% thought that, cared that they'd be reducing costs. And it's like, that can only mean that they don't understand what those costs are, which is probably true because only really the Fortune 500 measure this stuff because they want, their stock price to go up. Okay, coming into relevant case law and defensibility. I'm not going to be spending a lot of time on this either, but I think it's important to identify some key trends. Okay. Milner v. Department of Navy. This is a 2011 case. Its only real significance, and it's been in almost every FOIA presentation I've seen or done in the past 2 years, is basically that FOIA is being interpreted, whether it's on a federal level or a state level, as broad disclosure. And so these boilerplate arguments about things being too hard or exceptions applying, they're really not carrying as much weight as they used to. And I think judges are getting a little bit irritated with the narrow interpretation agencies are trying to have on FOIA. Therefore, I predict, and case law supports, it's going to be more expansive in the future. NDLON, massive case, has 5 separate decisions that have all come down. One specifically on custodian self-collection and the dangers of it, calling it the fox in the henhouse, meaning delegating legal hold responsibilities and data preservation to individual custodians is a problem. How do you address that? You address that through automation, not through depending on people for manual processes. So NDLON's major thing that I am focusing on now, though, aside from that self-collection issue, is they fought with the government about format types. Basically, the government produced in their productions things that could not be searched appropriately. And the opposing party wanted metadata. They wanted searchable fields. And I think we're coming into a time frame, especially as archiving and eDiscovery tools can be repurposed not only for litigation but for FOIA. We're coming into a time frame where you need to be able to use the same technology to do both. You want to kill 2 birds with 1 stone. Is your litigation workflow going to be exactly the same as it is in FOIA? Probably not, right? I mean, there's different considerations in legal standards and record standards. But what you do want to do is have the least amount of different processes possible, and you want to leverage the things that you already have. So NDLON, to me, points to the way documents are created, the way data is created is probably the way it's going to be produced. And it's got to have at least certain base level metadata fields behind it. That's all subject to, barring that there isn't a separate agreement between parties. But ultimately, I don't think it's going to be an argument that works anymore to say, oh no, we can't do that because that's FOIA. But in litigation, you're able to. Well, this is actually FOIA and litigation together. So that's what NDLON is. Any questions about NDLON? It's a really big case, and I'd recommend reading it if you have time. Okay. Flag v. City of Detroit. So here we see judges imposing the same requirements on governments that they are on private sector companies, but this isn't so much about so far down in the electronic discovery reference model. It's more in the beginning. So this is all about what were your document retention policies? Were they properly deployed? Were there audit trails to prove that? Was there spoliation? So governments are whether they have less resources, less manpower, whatever, they're coming to a point where they're held at the same standard as the private sector in litigation for these things. And then finally, this FTC Lights case. This is an interesting case. I know David Shanka from the FTC really well. We do a bunch of panels on legal hold together. The FTC is not yet at the point where they have automated legal hold, but that's where they're trending. And this case here, it was found that the FTC had a defensible litigation hold process, but it was messy. And they had to get a 30B6 witness up on the stand to talk about the massive Excel spreadsheets and the 3 million legal holds they have across 500 cases. And he did it. And there was a defensible process, and everyone understood what they needed to do. But it's almost unmanageable right now for him. And so what we're seeing is the legal hold process scrutinized in the government sector, and we're seeing move away from manual. Any questions on the cases?
What was that last citation to?
Right here?
Yes.
What am I speaking?
What court was it in?
Oh, I can get you the court name. I think it was in Washington.
Okay. It's
Yeah.
just a strange citation.
Yeah, it is actually. But I can get you the case name. I have a bunch of other presentations that go into this case in a lot more detail. But any questions about the legal hold or okay. So the 5 best practice tips. I think this is a good segue because here we go right into just saying that we need automated legal hold. I mean, and we'll also cover some of the major points of exposure that you have with litigation hold and how those can be addressed on a separate slide. But literally, and I think someone asked it earlier, there's just too many cases, too many custodians, too many employees coming and going with different access, and it's got to be something that technology tracks with an auditable record, not something that people are managing with Excel spreadsheets. Record keeping and FOIA requests. Again, back to the archive. I mean, I know that there are disparate systems for records management that are necessary and proprietary to organizations because of the nature of their business. I mean, different agencies need to hold different records and things like that. But what we do here to address the record keeping and FOIA requests, again, is the primary storage of the archive, not the backup, which is for disaster recovery. Massive volumes of data. So you want to automate these retention and expiry periods. You want to get rid of the trash. You do not want to be going back and paying to analyze things that shouldn't have been there in the first place. Nor do you want to expose yourself to the legal liability of emails that shouldn't necessarily have been there anyway. Again, with the caveat that if legal hold is in place, nothing can be deleted. Limited resources, work smarter, not harder. Let technology do that for you. Let the people, the process, and the product do that for you. And we've already talked a little bit about the digitization. So how many people in the room think that their agency is going to be going through a paper to ESI conversion in the next year? Or who has a need to do it? No one has paper. What?
We have a need, but no one's there's a real push against going digital.
Why?
I don't know. People who just can't get rid of that paper.
So
I take notes on my computer, on my
Yeah.
phone rather. Other people are writing.
yeah, I'm guilty of it myself.
Yeah.
But I mean, I'm just wondering from a discovery point of view, from an information governance point of view, like how then are these massive ESI productions happening along the paper, and how are they correlating? See, if you don't digitize the records and OCR them, then you can't put them into the repository to search them against everything else that gives it context. So this is where we're losing here. We need to digitize. My company doesn't even do that, but I'm just saying, it's important because it all comes into information governance, case management, and risk. Okay, here's the EDRM, the 9 steps that I spoke about. And this is really important. I think that if you could visit the EDRM website and just save this and keep it in a file, and every time you're having a conversation that involves any one of the steps, bring it out, because it will organize you. It'll organize the whole conversation with the stakeholders. Legal hold is really important to look at here because you see where it sits. It starts with identifying, but then you need to preserve and you need to collect. And 3 major things need to happen in order for legal hold to be defensible. You have to properly notify the custodian. So I think in many organizations that's done via email or maybe at a meeting, or I don't know exactly how people that are doing it manually accomplish it. But proper notification can't just be sending an email with no follow-up. It's got to be, I sent this to Joe checked a box and received it, and then I'm also iteratively checking back with Joe as the matter unfolds. You have identification. So the module that my company supports will email this, and then it'll say, Joe, do you have anything else you'd like to tell me? And Joe then has the ability to change the scope of the legal hold. So now we're not putting the onus on the custodian in order for them to save the evidence. We're extracting knowledge from the custodian, which they probably have the best knowledge of anyone about the data, to help us understand what the scope really needs to look like. So in that survey that you can customize, you could basically say, are there any other areas that we should be looking at? Are there any other devices? Do you know anything else about this matter? And then the lawyers in IT can zero in and zero out as appropriate via the survey. So this is like tremendous, because without this technology being automated, I'm walking to 300 people's offices to have that same conversation, that week. And it's not sustainable. And then the preservation, again, back to that, the things that are in an archive can be held in place. They can be locked down. That's why archiving is advised. There's always going to be information that's in the wild. That's anything outside of the archive. How do you lock that down? There are numerous ways to do it, but the one baseline thing you've got to do before you can have a defensible process is to at least notify the custodian that it should be done, right? So you want to pull as much as you can into the archive, and then the things in the wild you have to deal with on a case-by-case basis, depending on the medium of content and things like that. So is it social media? If it's social media, we may have to archive it, which is possible. There's a connector that you build from LinkedIn. This is true for all financially regulated industries. They have to archive their social media, and it goes into the vault. And then there's no question, because management, lawyers, and IT have the ability to go search it. Any questions about these steps here? Okay, let's talk about some of the challenges. So, of course, legal hold is fraught with complexity, especially if it's complex matter. We don't need to go over all of these, but what I think we should do is talk a little bit about the training of employees for understanding compliance. How many people in this room have received legal hold training? 3? 4? Okay. So, this is something, it's just like coming on board to a new company. It almost should be an HR element, because it subjects an entire agency's credibility and bad press and tons of things when legal hold isn't quite understood within the agency and what the responsibilities are. So, we do it at Symantec as part of our core training on everything else, privacy, sexual harassment, yada, yada. This is part of the training. So I think the most important thing is that, if Joe's working in a department where he doesn't deal with litigation and has no idea about how important something may be, he needs to appreciate why, when, where, and how of legal holds. That doesn't mean every person in the organization needs to know how many lawsuits are going on. They just need to be aware that they shouldn't be destroying data. If this is automated, you can forget everything I'm saying. So those are the challenges. And then the elements. I named the first 3 that lay the foundation, but then after that, you need the acknowledgement, you need compliance, the ability to audit, testify, and then train. And the training is iterative. So again, back to some core functionality about automated legal hold. You can have a report produced that says, if something were to come up in litigation or some question about the veracity of documents or chain of custody, you can point to the report and say, oh no, we notified this person, this date, they responded yes, and we locked down this amount of information. Oh, something's missing outside of the archive? Let's look into that a little bit more. But without that tracking, you don't have that power. You have no insight into the process. Okay, FOIA, best practices, people, process, and technology. So, I won't bore you by going through all of these either, but I just want to reiterate that what's beautiful about the information governance message today is, number one, that it's modular. So the two basic things I mentioned are archiving and eDiscovery capabilities. Archiving being proactive, eDiscovery being reactive. And the most beautiful thing today is that you don't need to put them all in at once to have it work. They can be implemented modularly. And when they are implemented and working in tandem with policies effectuated across that technology, so everything's married up, they accomplish multiple purposes. So if you're being sued, you have one workflow. If you have a FOIA request, you have one workflow. If you have an internal investigation that you don't need to be as extensive with, but you still need to do some internal searching, one workflow. But it's the same tools. That's not where we are today. Where we are today is we're using different tools, and I see this all over the United States and abroad, different tools for these similar activities and different technologies. And it gets even more complicated when you're dealing with legacy data in the context of different technologies. So if you can know that you're going to have crossover with FOIA and with the archive for litigation, then you should be able to repurpose your technology in order to accomplish a bunch of different things. It's an investment into the entire information governance spectrum. So we've talked about that automation and the benefits of that. Okay, let's talk a little bit about this case study. I mean, there's no real rocket science to this, except for we were dealing with an agency that had a major backlog and that had a manual process, and they didn't have an ability to cut down on the amount or way of information that they were dealing with. So in this instance, you can look from the process of the request all the way through to produce and close. That's what I mean. This is a similar workflow to the EDRM. This is very similar to litigation. So you're able to use the archive and the in-house eDiscovery capabilities. And then what ended up happening after we implemented this workflow was that there was a 61% increase, and they were able to get rid of their backlogs, right? So it's basically manual versus automated, and better workflows and more defined actions around the EDRM model. So just in summary for the tips, I mean, I think that we get automation is the way of the future. How many in the room feel like your agency is close to implementing technology that can take away some of the nightmares of your own jobs in data collection and maybe move to a more automated way? Is anyone close to that? Yeah?
Actually, ours is running pretty well as it is, based on what I hear here. Yeah, well, I mean,
Do you have Symantec products? No, I'm just kidding.
we have a pretty good backup system, and our recovery from backup is very easy. As soon as we get a litigation at home, we request back from 1 year, and they do restore and put it on a separate server. So our collection is completed.
So your backup and your archive are the same?
No, I'm not even sure about the archiving, but in terms of when there's a hole, we are able to pull everything and we just put it there and process things later. So, you know what, we're pretty convinced that we have a complete collection. And we do have policies in place that they're not supposed to keep stuff on their desktop, you know.
Yeah, PSTs are the nightmare.
You know,
Sure.
that sort of thing. Well, we have PST collection too. We have centralized PSTs. So that's already on our servers and backed up and part of that system. So in a sense, a lot of our work was already done for us when we implemented litigation hold. The backup people did a really good job in setting up the system.
Good. Is your legal hold automated?
Not at this point.
So is it an Excel spreadsheet exercise?
No. I use, well, it isn't even that way, but I use a database, not exactly SQL, but I'm a programmer, so
Okay.
I do it that way. And it's never that that complicated, because it's very specific programs. Someone suing us that they got too much tax, right? And we're a labor agency, and part of it's collect. So the scope is not these broad things. It's like, you pay me too much. So there are actually online systems that handle the tax for that. So you flag those records for that tax for that company, and they will not be deleted in a normal deletion process. That was the way the systems were set up.
But, and just kind of zeroing back out on information governance, though, that's great for discovery. But then
Right.
where is the real document retention policy across the information governance kind of?
Right, and for the discovery, that's the area where we definitely need to work on more. We have bought a tool, and it's coming along slower than one would have expected. Well, that's standard for state government. Right.
Yeah. Anyone else? Anyone else going through RFPs or have questions about automated versus? No? Okay. Yeah, and so basically, this is back to just the 5 things that if you're going to have a meeting with stakeholders that deal with these issues, I think talking about legal hold and what the process is, what the training is, and what the technology available is key. Talking about FOIA, back to you, how are you dealing with FOIA requests?
Actually, that's a term I don't know.
Oh.
I know it by another term. We have, what do you call it?
The California equivalent?
Yeah, public records access, PRA requests, that sort of thing.
Yeah.
Oh, well, actually, ours are, again, fairly simple, and the litigation whole group rarely gets involved. I don't know why. I'm starting to see maybe we're lucky. But
I think you're making a lot of people jealous, actually, in the room right now.
Really? I hardly ever see them. It's only when it's complicated, where it's on SharePoint and all this, that I get involved. Most of the time, the legal office just handles it. So I'm starting to see we are lucky.
Yeah.
However they set it up.
I know. I want to talk to someone with some problems. Okay, and yeah, and back to the 5. So talk about how you're doing FOIA and how FOIA could be streamlined against litigation. Meaning, get some tools in place that you can just tweak the workflows for and kill 2 birds with 1 stone. Massive volumes of data. I think that's always going to be the push and the pull in the government, right? Being the historian, the archivist, having to have all these records, but yet not wanting to keep trash. So that push and pull and trying to get your storage down so you don't have to pay more later to review it is key. And then with digitization and that transition, I think that the National Archives just came out, and I know this doesn't apply to California per se, but they just came out with a directive. NARA and the OMB, the Office of Management and Budget, and they're saying by 2016, everything should be digitized for the federal government, right? I think about California as as the keynote speakers were discussing, is one of the most progressive states out there, and it's like, I think that should be reflected in everything we do. So, and here's some people that have done it. So, whether it's Fed, SLED, whether it's FOIA or litigation, both, whatever drove these customers to consider information governance as a whole and then build it out modularly has worked for them. And they're all open to talking and can help any one of you if you have questions, as well as I can, and so can my team who's here in the room. And then this last slide I thought was important, especially since everyone seems to know who Gartner is. We worked really hard over the past year and a half to get ready for Clearwell and then to acquire Clearwell. And that's our reactive eDiscovery tool set. But forget the names and exactly what they do. What's important is that this whole industry is going to a more end-to-end solution, and that's the archiving and the eDiscovery. And you want to be a thought leader, and you want to be ranked where Symantec is in this. You need to be building your products so they work with other open frame products, but so that they also seamlessly work together to save the customer time and money and headache, right? So Gartner is also a good resource if you want to look at things. The electronic discovery reference model is as well. And then we have, of course, our eDiscovery blog, which I can definitely direct you to. It's Clearwell 2.0. But that's pretty much all I have for you today. I was hoping that there'd be some more questions or some use cases that we could discuss. Anything in the room? Yes.
Do you mean eDiscovery in simple terms? Are you talking about search capabilities? You can search the records. Is that a different term to explain under eDiscovery?
When I'm talking about eDiscovery, I'm referring to the electronic discovery reference model. Okay? When I talk about information governance, I'm talking about two things. One is proactive, which is archiving, and one is reactive, backward-looking, which is eDiscovery. This whole reference model here really depicts what the eDiscovery process is. And when we were on this slide and we were talking about expenses, expenses can be from $5,000 to $30,000 a gigabyte across all of those steps when you break it down. A major part of eDiscovery is the ability to search. And that's why you need to have in-house tools, and you don't want to be outsourcing all of this to vendors, right? Because you want to decrease the costs and the steps that vendors do on the EDRM. You want to own that as a business process internally. Does that make sense? Come on.
I have a question. Does, you talked about the paperless, moving to paperless, the transition. Does Symantec offer tools to assist with that? And can you describe some projects? So you showed examples of agencies that have sort of moved in that direction. Can you talk about those, any of those processes that they went through and what was involved?
Through digitization?
Yes.
Symantec doesn't do that, but we partner with people that do that. Symantec's sweet spot is the proactive information management, which is the archiving, and then the eDiscovery, because we purchased Clearwell, which put us at the top with the Gartner Magic Quadrant. What I've seen is agencies go through, I'll just name one company, but it's not an endorsement, and we can talk about some others. I've seen agencies and oil refineries and people, the private sector companies that still have a lot of paper, go through digitization with a company called Beyond Recognition, which then was able to allow the agency to put those electronic documents into the corpus of data that gave them relevance for the litigation. Whereas operating separately, there's no context, right? You have different lawyers with boxes and paper, and others on a hosted solution looking at an interface making, attorney privileged calls about documents. If you get them all together, you can intelligently break the case apart for more strategic benefit. So, how many documents are we talking about that need to be digitized? Because if it's a massive project, it would be like phases, and then you introduce them to your archive.
I think it's so massive that it wouldn't be retroactive to digitize existing records, but a way to move towards that by new records that come in, digitizing them.
That are still being created with paper.
Right.
Yeah. See,
For example, reports that come in or correspondence that comes in, you can't control, as a state agency, you get lots of letters.
of course, yeah.
Things, and so trying to manage those documents in an electronic way is a pretty substantial undertaking.
Yeah, so I have a good example from the Singapore High Court or the Brazilian High Court, because we've been working with them on these things. They have that same paper problem, and they've basically set up a station within one of their offices that when that correspondence comes in, they go through the OCR there, and then it feeds immediately into the archive, given the proper retention schedule, record classification, and expiry date. From cradle to grave, they're allowing that document to have activities assigned to it at the outset. So if that's something you're interested in hearing about, we can talk more about that too. It seems like for governments dealing with as much data as we're talking about in this room, it's the only way. Well, I hope this was helpful for everyone. And if anyone wants a follow-up or a demo or a question, let us know. Thanks.